question 252, is that right? Oh, good, 252, yes. Oh, question, this is our Catechism on the Constitution of the United States. Arthur J. Stansbury's Catechism, that's a series of questions and answers that the student learns. This is about our Constitution. 333 questions, this is question 252. Now, question 252 assumes you know what question 251 is, and so I'll read the question, then I'll explain it because it's assuming that everything is done in order, and then we'll read the answer. Can he take his case, his cause, from the state courts to the courts of the United States? Can a litigant take his case from the state courts to a court of the United States? Remember, we said yesterday, if you were here, there are two sovereignties in our country. We're the only country in the world that has this arrangement. Because nobody ever thought there could be two sovereigns on one mass of land, one country. And we did it. Two sovereigns that operate simultaneously. The states got together and said, we're going to give some few limited scopes of jurisdiction. A few limited scopes of jurisdiction to a national government, which we'll call the general government of the United States. That's what they used to call it. They didn't call it the federal government. They called it the general government. Why? Because within that small scope of authority that the states gave them, and they did it through the Constitution of the United States, within that small scope of authority, everything that they say, every piece of legislation that comes out, everything that they do, our Constitution requires that they apply it generally without favoritism. It has to apply to everybody the same. That's what the word general means. General means it applies something that is general. It applies to across the board the same. That's why we have in the U.S. Army a general officer called a general, because when he says something, it applies to everybody under him, and there are a lot of people under a general. It applies to everybody equally in the same. The order is the same. When Eisenhower said, okay, I'm putting out the order, invade Normandy. Well, that went out to all the armed forces that were in England at that time, and all the British forces. He was in command of those too, and all the Norwegians, and all the Canadians, and all the Australians, and all the, if there were any French, them too. It was an order that applied generally to everybody. He didn't go into details. All he said, well, listen, all he said was, go. Now, on the 6th of June, no, go, go, go. That's all he said. That's a general order. See, it's not specific, but even though it's general, it applies, though, to everybody the same. Well, our Constitution of the United States has given to the general government, there's that word again, in Washington, D.C., in a few small areas of jurisdiction. And when the general government in Washington, D.C. speaks, it has to, according to the law that limits that government, it has to apply to everybody the same. Why? That's why. That's why. The preamble says, watch me, and look for the word general in the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare. Promote the general welfare. Do ordain and establish this Constitution for the United States of America. General welfare. Our Constitution does not give authority to the government of the United States. Hear me well. It does not give authority to the government of the United States to give food stamps to folk of low income. It does not. It never has. You say it's brutal. Some people need the money. That's a state question, friends. That's a state question, not a general government question. That's not providing general welfare that applies to everybody the same. That's just one example, just one of the general government in Washington, D.C. going, outside the scope of the authority that the militiamen of the several states have given to the general government using that document called the Constitution of the United States. So their jurisdiction, the general government, is limited. They're sovereign within their jurisdiction. Yes. Yes. Did you know that sovereigns don't have the power to tax each other? And that question has come before the Supreme Court of the United States, and the Supreme Court of the United States said no. No, the government of the United States cannot tax the government of the state of Indiana. No. And the state of Indiana cannot tax the government of the United States. No. And the government of the United States is not confined to the boundaries of the states. I know one place, no kidding, one place where I'm from, there are probably more across the country I don't know about, but the U.S. Postal Service and the postmaster, his jurisdiction in one place I know about, unless they've changed it, it went across the state line from one state to another, Illinois to Indiana. Because the general government in Washington, D.C. is not, the state lines are not what rule them and define what they do. No, they're the general government. And everything must apply the same. They're at liberty to, did you know that U.S. Postal Service, the folks that drive the little Postal Service trucks and around town, and if you're living in a little town or a big town, the folks that drive those things don't have to have driver's licenses from the state where they live to drive them? Now, unless, again, something's changed. It used to be that way. I learned this looking at constitutional law. There were cases that came up. I'm arresting this guy. He doesn't have a state driver's license. Goes to the court, and the court says, well, he didn't work for the U.S. government. He didn't have to have a state driver's license to do his job. That's sovereign. When I was an armed forces man, I had a license from the armed forces of the United States to drive armed forces vehicles. And I did. In the San Francisco Bay Area. I drove trucks. We go pick up supplies for our division, our outfit. I'd drive a truck over to Treasure Island, pick up supplies. I had a driver's license from the Armed Forces of the United States. I didn't have a state driver's license in California. Why? Because the general government in Washington, D.C. is sovereign. They don't have to get permission from somebody else, like the states, to do something. And vice versa. Vice versa. But welfare is a state matter. That's a jurisdiction that belongs to the states. Do you see something in the Constitution of the United States that says that the government can hand out food stamps, the general government in Washington, D.C.? No. And if it isn't there, then they don't have that authority. The Four Corners Doctrine applies to our Constitution. It says what it says within the four corners. Nothing outside can come in to dictate over what it says. Well, it's a good thing to do when people are starving. Well, okay. The states are supposed to take care of that. And if your state doesn't take care of those things and have legislation and machinery in place to take care of those things, political machinery, government machinery, and it's that bad, well, you better get to another state. That's the beauty of living in America. You don't like it in one place, you can go to another country called another state, another jurisdiction. We need to be thinking in those terms, not the way the media wants us to focus on the presidency, the Congress. What do you know about your state government? What do you know about your township government? That's where government is. Well, if you're in a state court, that's a sovereign set of courts, different than the federal courts. The federal courts are a sovereign system by themselves. Okay, this says here, can you take your cause from the state courts to the courts of the United States? From the state court system to the federal court system. At the top of the federal court system is the Supreme Court of the United States. Can you do that? Answer, no. I'm interested to see what he says here because I don't agree with him so far. I disagree, but let me go on. No, not unless his cause has to do with a law made by a state which he supposes is contrary to the Constitution of the United States. There it is. The question can be settled, that question can be settled only by the Supreme Court of the United States. What's he saying? Now, let's go over this again. We went over it yesterday. Maybe you weren't here. Courts in your state, the courts in your state, the trial court, the Court of Appeals, the Supreme Court of your state, all of those, starting with the trial courts at the bottom, that's where you enter the system. That's where you file a case. All of those courts are courts of unlimited jurisdiction. Those courts can hear, state courts can hear anything, any matter, any issue that comes up, except what the Constitution of the United States says belongs exclusively to the general government in Washington, D.C. If the Constitution says these jurisdictions belong to the general government in Washington, D.C. and the courts of that federal system, then the state courts can't hear them. What are they? Exclusive jurisdiction of the courts of the United States, the federal courts, are bankruptcy. All bankruptcy courts are federal courts. Second, admiralty cases, cases having to do with ships on the high seas, sailors on ships on the high seas accused of crimes. Watch this one. Admiralty law takes in all aviation in the country, crimes committed on aircraft in the sky or about to embark or having landed. Those crimes are federal questions under the Constitution of the United States. Those go exclusively to federal courts. State courts have no jurisdiction. When I say state courts have unlimited jurisdiction, can hear any case, that is true except the few cases that our Constitution of the United States says are exclusive to the federal courts: admiralty, bankruptcy, martial law. So martial law and admiralty are two species of martial law. And then bankruptcy. By the way, drop a footnote. What is bankruptcy if you had to define it? What is it? What powers does a bankruptcy court have? I'll tell you what powers they have. Remember this. If you remember this, everything else comes out of this one thing. Bankruptcy courts have the power, that's a federal court, see, has the power to impede or end obligations, debts of contract. That's fundamentally what bankruptcy courts do. They can impede, modify, or cancel promises of debt. What is a contract? It's a promise that creates a debt. At least one, maybe two, maybe going both ways. Show me a contract, I'll show you at least one debt. Maybe two. Show me a debt, and I will show you a contract. Show me a duty, and I will show you a law from government. Taxes are not debts. That's patriot mythology. Taxes are duties to pay. You don't pay taxes because you made a contract with somebody. You pay taxes because you're doing a certain thing that puts you within or you're within a certain geographic area that puts you within the jurisdiction of the sovereign, the state, or the general government, depending upon what it is. There's a lot of abuses in all of these concepts I'm talking about. But just because they're abuses doesn't mean the law is not true. Let me say it again. Debt arises out of contract. Obligation, duty, arises out of law. Taxes are not debts. They are duties. That's why our Constitution of the United States calls them duties. Talks about taxes and duties. Duties is a synonym for taxes because taxes are not debts. And that's what our courts call them. Well, the general government in Washington, D.C. has limited jurisdiction to those few things our Constitution grants to those federal courts, those few areas of law. And state courts have unlimited jurisdiction, can hear any case that arises, except those few I mentioned: bankruptcy, martial law, governing armies, our military forces, admiralty law, martial law, bankruptcy, piracy and felonies committed on the high seas. That's another one, has to do with maritime law. Violations of international law. Those are jurisdiction of the federal courts. Well, there is one other exception. I'll mention it briefly, where the courts have jurisdiction, and that's cases where the law of Congress, passed by due process, by duly passed, signed off on the president, where a law has not been declared unconstitutional by the courts. That particular law, if Congress says that the general courts, see, they're the masters of the courts of the United States. Well, in this sense, Congress creates all the courts of the United States, except one, federal court. Congress creates all courts of the United States except one, and that's the Supreme Court of the United States. Our Constitution of the United States directly establishes the Supreme Court of the United States, the Office of Presidency, and the Congress of the United States. It establishes three branches of government. And then the Constitution gives authority to the Congress to establish any other federal courts they want to establish, if they want to. All the federal courts under the Supreme Court are creatures of Congress. Therefore, Congress has authority to define what jurisdiction they have. And if they say the jurisdiction we're giving the federal courts under the Civil Rights Act of 1964, Section 1983, they say, our legislation says the federal courts have exclusive jurisdiction over civil rights actions. Well, if they say that, they're the ones that created the court. They have the power to say what that court can and cannot do. And they have in those few cases. But the general rule, there's that word again, is that state courts have unlimited jurisdiction, and the federal courts are courts of very limited jurisdiction, limited to any case that arises under something in our Constitution of the United States, and that's very limited.